Welcome back. Kousha Adhami from Adhami Law Group. Today, I'm going to talk about green card marriage cases for individuals that have previously been in immigration court proceedings and they are currently in immigration court proceedings, okay? And what are the options available for them to get their green card? Stay tuned. Today, I'm going to talk about and explain a very specific area of the law that allows individuals to apply for their green card while they're in immigration court proceedings. Okay, so let's ask the first question. Okay, what is cancellation of removal and who is eligible for cancellation of removal? Okay, so there are two types of cancellation of removals for individuals that are in immigration court. Today, we're going to talk about 42B cancellation of removal for individuals that are undocumented and they are placed in immigration court proceedings. Okay, now, these individuals can apply for their green card based on their 10 years of physical presence, continuous physical presence, and a hardship that the removal will cause to their qualifying relative. Okay, now let's go more in detail. Now, to qualify for cancellation of removal or 42B, you must meet these following three requirements. Number one, the individual or undocumented person must have lived in the US for at least 10 years continuously before immigration court proceedings began. Okay, so two things. Number one, they have to show 10 years of physical presence continuously. Okay, but they have to show this 10 years of physical presence requirement before immigration court proceeding has been commenced against them. All right, this means is what we refer to is the notice to appear. So when they are issued a notice to appear and they're sent to immigration court, if the applicant can show 10 years of physical presence from that day before, for example, if they're issued a notice to appear for January 1st of 2025, so they need to show that they've been physically present for at least 10 years prior to that date. So we're looking at 2015 to 2025. Okay, that's the first part. The second requirement is that the applicant must show that they have a good moral character during that 10 years. Okay, so what is good moral character? How would you define a good moral character? Good moral character means that the person did not commit certain crimes or engage in behavior that shows that they're not dishonest, dangerous, or morally unfit to stay in the US. Okay, now, a common example of good moral character usually refers to individuals' criminal history. So if you have been convicted of certain crimes, you may not be eligible for this program because that would affect your good moral character. But if you had only one minor criminal record, like a DUI or a reckless driving that is shows on your criminal record, you may definitely qualify for that. But it's very case by case, and the judges in this type of cases have the discretion, okay, to look at the totality of circumstances in this case, okay? But good moral character is a second requirement. The third requirement, in my opinion, I think is the most important requirement. This is the requirement where the applicant or undocumented individual must show that their deportation would cause exceptional and extremely unusual hardship to a US citizen or a green card parent, spouse, or a child. That's a mouthful. Okay, that's a lot of, words and concepts in one sentence. So let's break it down. So the individual must show that their removal from the US would cause exceptional and extremely unusual hardship to a qualifying relative. In this case would be a parent, a child, or a spouse. Okay, so the definition of a qualifying relative in this case would be parent, spouse, or a child. And child is defined as someone who is under the age of 21, as I explained earlier in this case. Okay, now once you have proven the relationship of the applicant, okay, in court, then you've established that they are either green card holders or US citizens, then you must establish and show what the hardship is. Okay, so this standard, exceptional and extremely unusual hardship, is a very, very high standard to prove. Okay, it's not your average extreme hardship standard. Okay, that means you're looking at somewhere around 70% and above the standard of proof. Okay, it's not similar to like preponderance of evidence, which is required in criminal courts, but it's still a very high standard. So for example, one of an example would be if the child needs medical care or medical attention. So for example, if a parent who is undocumented is in court and their child is, for example, if they have autism or Down syndrome and they need continuous medical care, that could be a good standard of proof for this very high, exceptional, and extremely unusual hardship. Okay, because it shows that the parent's removal, but for example, a mother or father, which is in this case, their removal would cause this hardship to a US citizen child. Okay, and this extreme and exceptional and extremely unusual hardship, which is even mouthful for me, the code made it this hard on purpose because not everyone would qualify for this. So for example, if your child has ADHD or ADD, that doesn't necessarily qualify you for this case. So for example, another example would be if your US citizen or a legal permanent resident spouse has like cancer, okay, and they need continuous treatment. That could also be a case for it. Is it gonna be a slam dunk? Maybe yes, maybe no. It varies because the judges will look at the totality of circumstances. Okay, the other consideration that the judges will take and the other factors are, for example, the condition of your home country, the financial hardship that your qualifying relative will experience if you're removed, the mental and emotional impact of this process being removed. Okay, so all those will be taken into consideration, but there are a couple of things that I want to recap before we end this video. Okay, number one, 10 years of physical presence before the court proceeding commences. Number two, you have to have 10 years and during that 10 years you have to have good moral character. You have to show a good moral character. And number three, your removal, the undocumented person's removal that is in court, their removal would cause exceptional and extremely unusual hardship to a US citizen or a green card spouse, child, or a parent. Okay, even if you get this case granted, for example, in front of an immigration judge, you may not get your green card right away because there is a statutory cap of 10,000 visas per case that's issued for these cyber cases. So even if you get the judge to approve your case, you may not be able to obtain your green card for maybe a next year, or you have to wait 2 years until those visas are available. For more information, please visit our website at adhamilawgroup.com or call our office at 213-204-6500. Stay safe.